Please be seated. We're ready to hear argument in 2179, in re Poe Trust.
May it please the court. Ms. Eckery and Mr. Mobbs will present argument for the petitioners. Petitioners have reserved 5 minutes for rebuttal. Ms. Eckery will open with the first 10 minutes and will present the rebuttal.
May it please the court. The Court of Appeals found a jury right that no Texas court has ever found. It has no basis in the Texas Constitution, which grants a jury right in causes, not in special proceedings like trust modifications. A trust modification is created and controlled by a statute that ascribes this discretionary determination to the court alone. Not surprisingly, in the almost 40 years since the legislature enacted the trust code, trust modifications have been tried routinely and exclusively to the court. This was also the historical practice before the trust code's enactment. This long-standing practice is correct. A trust modification has no characteristics of a cause for which there's a constitutional right to a jury. Equally important, the nature of the statutory inquiry makes jury involvement fundamentally unworkable. This court should reverse the Court of Appeals judgment and confirm that, consistent with the Constitution, the trust code, and the historical treatment of such issues, there's no right to a jury trial in a statutory trust modification. I'd like to talk a little bit about why a trust modification doesn't qualify as a cause under the Texas Constitution. The court's cases in which the court has delineated whether there's a jury right or whether there isn't has never really set forth a comprehensive test for whether something's a cause, but there are several factors that you can look at. And the first is, does the proceeding have the attributes of a typical cause of action? Are you seeking a judgment against the adverse party? Here, there's no judgment sought or obtained against the opposing side. The only judgment that will be obtained is a new order, an order creating a new trust. There's no plaintiff, no defendant. The language of the Constitution applies to plaintiffs and defendants. In election contests, by analogy, the court said this proceeding has no characteristics of a cause because nobody will obtain a judgment against another party. Even though the county attorney is made a party, he's a party in name only because there won't be a judgment rendered against him. There's no personal right of the trustee involved. This isn't Anthony Bach versus Richard Poe. It's in the interest of the Troy Poe Trust. And that's significant. And I do want to point out one thing. In this trust modification, Richard did counterclaim against Mr. Bach for breach of trust. And the trial court has severed out that counterclaim, and that is going to be tried to a jury. So what we're talking about here is really just a very narrow category of cases that fall under the statutory trust modification, and that's where there is no jury right. Another characteristic is whether the court is acting in a special capacity and exercising its power over something or someone. And I think a good analogy here is a receivership. Like a trust, a receivership also involves a fiduciary duty. The receiver acts like a fiduciary with respect to the receivership property. The court, however, is charged with managing that property. It's in the custody of the law. And the reason there's no jury right in receivership cases is that the court is the fact finder. The court has the right to set the rates the business is going to charge, supervise the receiver, and do all things necessary to run the business. And the cases hold that if you let a jury set the rates and do any necessary fact finding, you're transferring control from the court to the jury, and that's impermissible.
But here the court doesn't control the trust, the trustee does.
The trustee is charged with administering the trust, but the court has supervisory power over the administration of trust and the trust property.
But it's not in the custody of the court.
You're correct. It's not. So it's not exactly like a receivership, but there are parallels. A trustee is a fiduciary with respect to the trust property, just like a receiver is. A receivership, you have to join all parties with interests in the receivership property. Just like here, you have to join all trustees. So it's not a perfect analogy, but there are some comparisons.
The
Another,
fact that it was historically equitable doesn't help you, right? Because equity issues of fact still get tried to a jury as a cause.
in Texas, you're right. There's no blanket rule against jury trials and equitable proceedings like there are in some states. But that doesn't answer the question of whether it's a cause. There are lots of equitable proceedings that are not causes, like receiverships, like family law issues. Until the legislature granted a jury right in 1961, child custody cases were not tried to the jury. They were exclusively tried to the court. And if the equitable nature of the proceeding dictated whether you got a jury, all those cases would be wrong, saying that family law is not a cause.
It is an adversarial proceeding.
It can be. There's no justiciable controversy required, but it can be. You can have, like we have here, a trustee opposing the trust modification. But again, you're coming to court to asking what is permissible under the trust. What are the trust purposes? Can we change it so that those purposes can still be fulfilled in light of things that have made it impracticable or impossible to fulfill?
If we disagreed with you that judicial modification of a trust precludes any role for a jury under all circumstances, in this case, has any of the grounds for judicial modification just been conclusively established? Like, it's undisputed that one of the co-trustees is dead, and that the two remaining have disagreements about the management of the trust.
Your Honor, we believe they have been conclusively proven. We raised that issue in the Court of Appeals, and the Court of Appeals held differently, and we have not pressed that in this court. But I agree with you. I think that impossibility has been shown. But you raise a good issue, because there are practical problems with submitting this case to a jury. And I'd like to run you through the statute. It's in the bench book, tab 1.
So we have the statement in 1907 that's broad. What's the earliest statement to the contrary from this court?
You know, there are statements preceding that in election contest cases saying this is not a suit. It's not a cause under the Texas Constitution from the 1800s. But then you're right, there's a 1907 case saying any contested fact is a cause. But then 3 years after that is another election contest case where the court says the language of the judiciary article does not embrace contested elections as causes in which the right of jury trial is secured. The grant of jurisdiction to courts does not convert such contests into causes, as that term is used in the Constitution. Then 27 years later, in Texas Liquor Control Board versus Jones, the court again invoked the idea of a cause of action as the defining term. And it said, the cancellation of a permit to sell liquor under the Liquor Control Act is not a civil suit or cause of action. This special summary proceeding is not a cause of action within the meaning of the Constitution, and there was no jury right under the judiciary article.
Should we look at what causes of action were in the 1870s, or I mean, how do we approach that?
So Professor Harris wrote a law review article on this, and this court cited it in the Credit Bureau case in 1975, and he says cause of action at the time, even at the time of the Toll case in 1907, and he looks to the law dictionary that this court looked to in that case, and he said, look, even at that time, cause of action meant a violation of a duty and the existence of a duty and a violation of that duty. He said it means the ordinary cause of action, even back then. And he kind of takes that thread through all the court's cases, and he says that's how you can make sense of all these cases.
But what if it's statutory, as we have here? I mean, that's not something they were thinking about in 1907. So
Right.
should we just look at the statute and see what it says the court's supposed to do and what it's silent about who does, and say that the things it's silent about the jury should do?
Well,
If they look like questions of fact, such as the purposes of the trust have been fulfilled or have become illegal or impossible to fulfill.
So that's a good question. I'm not sure that is a question of fact. And so the first one and then the second one, because of circumstances not known to or anticipated by the settlor, the order will further the purposes of the trust. I think both of those have legal questions mixed into them. Impossibility is typically a legal question. It can be
But don't we
factual.
submit mixed questions of law and fact to the jury all the time?
We don't submit mixed questions of law and fact. You mean separate out the factual parts of it?
Well, did somebody breach their duty of reasonable care, a mixed question of law and fact?
No, I think that's a factual question.
Solely.
I think so. But I think the reason this is difficult to answer is that they are mixed. And let me just read you one snippet from a Hornbook, the Loring and Rounds Trustees Handbook. They say the typical equity issue is a law-fact hybrid that's not easily transmogrified into a clean fact question. Take, for example, a Uniform Trust Code trust modification proceeding with two critical predicate questions that need to be answered. Were the circumstances now prevailing unanticipated by the settlor, and are the trust purposes now impossible to fulfill? Each has a heavy law component to it. Each calls for a parsing of the terms of the trust instrument in light of the circumstances surrounding its execution, as well as a general appreciation of what equity is all about. Jurisprudential context here is critical. Still, in Texas, such questions are being put to juries. And they point out that these provisions came from the Uniform Trust Code, yet the Court of Appeals interpretation in this case has really made Texas an outlier in recognizing a jury right here. I see my time has expired.
Mr. Chief Justice, and may it please the court. Before I get into what I want to argue, which is the practical effect of the Court of Appeals decision, I'd just like to note that the Hornbook quotation that counsel just read to you cites to this case to support the proposition that these questions are being submitted to the juries in Texas, not that there's some history of submitting these issues to juries in Texas. And in fact, courts have always, in exercising their powers of administration over trusts, in equity, even before the statute was enacted, decided whether it was necessary or appropriate to modify a trust instrument in order to further the purposes of the trust. And it works that way. Overlaying this jury trial requirement on a court's ability to exercise that power is not only impractical, but it poses a real risk of harm to trust beneficiaries, and especially disabled trust beneficiaries like Troy Poe, when there's an urgent need to modify the terms of a trust.
But if the legislature has balanced those things and decided that the jury trial right is more important, then don't we have to defer to that?
Had the legislature done so, of course, but the legislature has not done
And
so.
isn't our general rule that if it doesn't say otherwise, the jury gets to decide it?
I don't think that's correct, Your Honor. I think that the usual rule is if there's a cause, there's a constitutional right to jury trial. If it's not a cause, then you look to see if there's a statutory right to jury trial. If there's no right to jury trial granted by the Constitution, which we believe there's not, and there's none granted by a statute, then there's no right to a jury trial. There's not some underlying jury trial bedrock principle that exists independent of the Constitution and independent of any jury trial right, statutory jury trial right.
Is there a defendant in this proceeding?
There's not. There's not a plaintiff. There's not a defendant. There are parties interested in the administration of this trust, including Troy Poe, the beneficiary, as well as the two trustees. In fact, this action by statute can only be brought by a trustee or a beneficiary of a trust. It can't be brought by some third party who might have some other interest in the administration of the trust.
And to be clear, if all trustees and all beneficiaries agreed to the modification, you'd still have to have a court order approving it?
You would, and that would, I think, be the more common circumstance. That some situation arises, the trust, for whatever reason, can't be administered practically. Maybe a corporate trustee goes out of business, you need to amend the trust instrument to name a new trustee, everyone goes into the court exercises its administrative power, and a new trust is created, or a new trust language is created to modify the trust.
If the parties didn't go to court and they just all signed amended trust agreement documents and operated thereunder, unless and until someone objected, there wouldn't, it'd just be they're operating in a void space, I guess.
I think that's correct. The trustees don't have the power to modify a trust. The settlor, with the consent of the trustees, can, if the settlor is still around, modify a trust. But, in a case like this where the settlor's passed away, that the trustees can't legally modify the trust document or change their own duties without court approval.
Is there no right to a jury trial on an interpleader because there's no plaintiff and no defendant, but just parties interested in the sum?
Interesting question. I would say that would typically be considered a cause, because that's an action to determine rights to property or interests in property.
Isn't this?
Not exactly.
You're determining who's exercising control over property.
But you're not determining who owns the property. The trial court's not determining who owns the property. It's determining how the exercise of control over the property for the benefit of the beneficiary is administered.
Do you agree that the exceptions clause in Section 10 of Article 5 applies only to the jury fee, with such exceptions as may be prescribed by the legislature?
That's a really interesting question. I have not looked at that. I don't have a position on that.
We were trying to determine what the word cause meant to an ordinary Texan in the mid-late 19th century. What would we turn to?
I think you would look first to the language specifically of that section of the Constitution, which not only uses the word cause, but uses the words plaintiff and defendant. So that would indicate that a cause is something, where parties are trying to determine who in justice has a right to recover or may be held liable.
You wouldn't think that the legislature, just by giving a different label to something, would be able to evade that understanding because
No.
it's not a plaintiff or defendant?
No, I think cause, you're trying to determine what cause means, and a cause is a cause, even if you call a plaintiff a petitioner or a defendant a respondent. But, in a case like this, there's not a plaintiff, there's not a defendant, because these parties are not pursuing the types of rights that are pursued when a real cause is at stake.
Any other questions? Thank you, Mr. Mobbs.
Thank you.
We'll hear from the respondent.
May it please the court, Mr. Stanton will present argument for the respondent.
May it please the court. Our argument is very straightforward. This is a cause. Whether or not it is labeled petitioner or respondent is inapposite. Yes, there's a fundamental right to a jury trial in Texas. Yes, a court could, to answer some of the questions we've already heard from the panel, there could be a time when a trust could go to court and a court could just prove it up if the parties agreed. Or, for those of us who have spent time in trial courts, there's all kinds of reasons why lawyers don't want cases tried to a jury. They can stipulate, they can waive the right, they can have it heard before the bench if they want to. It is inconceivable to me that this court would put itself in a position under 112.054 to state that whether or not the purposes of a trust have been fulfilled or have become illegal or impossible to fulfill could not be sent to a jury. Any of us who have spent any time in the pattern jury charge know that you can submit impossibility to a jury. You can submit illegality to a jury in a commercial context. Those things can happen. They happen regularly.
What about the purposes of the trust? Is that just, do you have an instruction on that? What does your charge look like?
Well, it's
How does
not.
the jury divine what the purposes of the trust are?
Well, there is a role for the court in this, and for the trial court in this, and I don't want it to be confused because some of the arguments in the appellant's briefing skip over this, which is the probate court or the district courts, and then wherever there's a probate court in that county, there is a role for the court to play outside of the jury. But there are factual issues unless the legislature clearly makes it so in the statute that it is a cause and it can be tried to a jury. Not everything under 112054 goes to the jury. This is clearly a judicial function. But when there are fact issues and a party, and it's clearly a cause, that the issues of illegality or impossibility, or whether the circumstance is not known or anticipated by the settlor, will further the purposes of the trust. Those are clearly disputed factual issues that evidence needs to be considered on. And I do not understand how the appellants get to this place of, oh, there's no jury, there's no issue that can be tried, there's no disputed factual issues. Those are clearly disputed factual issues.
My question is more specific about the phrase, the purposes of the trust, which appears in both 1 and 2
Yes.
of the statute. Is that language you leave to the jury to figure out, or who is deciphering the purposes of the trust for the jury?
Certainly that can be decided by a jury. The same way in any breach of contract case that this court hears, the jury decides whether or not there's an ambiguity before they decide whether or not there's a breach.
Well, doesn't a trust usually set out its purposes in the document itself?
Absolutely, Your Honor. The
And
same
so
way a contract.
why wouldn't the judge say the purposes of the trust are in the charge, colon, and then put the language in there from the trust instrument?
Ken, the same way you would submit a breach of contract case. Go to the PJ, say on business. If you're trying a case and there's a contract, the parties say there's an ambiguity or a problem or the purposes of the trust, you submit it to the jury. Is there or is there not an ambiguity? It's the very first question. So juries can do this, and they do it regularly. They can look at
it seems like the court might resolve any ambiguities in the purposes, but still, or maybe not. But if there is no ambiguity, wouldn't you just put in whatever's in the trust instrument?
Well, of course. Of course you would do that in that circumstance. But the issue presented, Your Honor, the threshold issue is, are there issues that should go to the jury? And then this court, if the jury, if the court granted the jury trial right, then the parties would argue over the charge. It happens all the time. One party will say there's an ambiguity or not, and the court finds as a matter of law there is no ambiguity. And if the trial court screwed that up, then the Court of Appeals or this court would go back and say, you should have submitted the ambiguity question, you messed up.
You said, of course, this is a cause. Can you play that out? Because the other side says this is definitely not a cause.
There's no authority to suggest that this isn't a cause. You can clearly look.
The petitioner cites a 1879 case about election contests where this court, around the time of the adoption of this provision, said that an election contest did not include a right to a jury. I didn't see that addressed in your brief. I wonder what your response is to that.
I think we did address it in our brief, but obviously I don't have full command of that right now. I'll try to find that. We don't dispute that election contests do not get a right to trial by jury. The same way with the other cases that the appellant cites about the Public Utility Commission and administrative rights.
What rule can we derive from those cases about when something is a cause or isn't a cause?
I don't think you need to look further than this court in State of Texas versus Credit Bureau of Laredo in 1975. This court's very clear on what a cause is. The court then defined the terms to mean any legal process which a party institutes to obtain his demand or by which he seeks his right. This broad meaning of the word cause comports with the interpretation given by other courts and legal writers in the period when our present Constitution was drafted.
But why wouldn't that broad definition include election contests?
It certainly could, but it didn't at the time. And most importantly, Your Honor, the Houston Court of Appeals in the Coffey case that we cite, which is not at all addressed by opposing counsel, which is a writ refused, no reversible error case, the Coffey versus William Marsh Rice University, this is where the trial court there, this is at page 283 of this opinion, while we have concluded as a matter of law from the language of the trust instruments that the primary purpose of the donor was to establish an educational institution of the first class, the careful trial judge submitted the question to the jury, which found as a fact that such was his primary purpose. So, Justice Busby, to your point, and also to your point, Your Honor, and again, this is a writ refused, no reversible error case from 1966. It was before the trust code was enacted, because that was in the 1980s, so we acknowledge that. But this is, the opposing counsel is doing the best they can. They got horn books, they got law review articles, they got all this. Here's the bottom line. In Texas, in the recent past, trial courts consider trust modifications. The First Court of Appeals affirmed that, so it can be done. It has been done. And more importantly, this court had no reason to grant a writ because there was no reversible error in that case.
Is there a defendant in this proceeding?
There is not a defendant in this proceeding. However, there's a...
So let me stop you there. Doesn't the Constitution give the right to a jury trial to a plaintiff or defendant and uses those words to describe who can invoke this right?
Yes, those specific terms are used. And I think to a point that was made earlier, if this court were to decide that plaintiff and defendant had to mean plaintiff and defendant rather than petitioner or respondent or applicant or wanted to take that strict of a reading on it, then this court could. But there's no... When the legislature wants to take away the right to a jury trial, it knows how to do it. And in this case, under one...
The question, though, is not... I mean, if you just change the labels, I'd inclined to think it wouldn't make a difference, right? But,
yes, Your Honor.
But the question is whether there is a difference in substance between the position your client's in and the position of a conventional defendant.
We disagree.
We're just not talking about labels.
Yes, we disagree. I mean, here, opposing counsel says, oh, here, there's not going to be a money judgment. There's just going to be a judgment with a new trust. Well, of course, that's what the fight's about. That is the fight. The fight is about whether or not the trust can continue to operate and whether these factual issues should have been presented to the jury when a proper jury demand is made.
And their point is that that's an outcome you may not like, but it's not an outcome that is imposed upon you directly the way a judgment against a defendant is.
I mean, no, not in the exact same way, because it's a trust modification and there's trustees. But it is still, there is still a plaintiff. There is someone bringing an action in court against another person in court regarding legal rights and legal responsibilities. And we believe that meets out the same type of definition that this court, the broad definition that this court set out in State versus Credit Bureau of Laredo. The term cause is defined in Black's Law Dictionary as a suit, litigation, or action, any question, civil or criminal, litigated or contested before a court of justice. And that's the United States Supreme Court citing that in 1866. So if we want to go back, and so that's on, this is a short opinion by the court, but it is on page 292 of State versus Credit Bureau of Laredo. So this court has already found that broad reading of it, looking back to the way the United States Supreme Court defined cause in 1866 around the exact same time. Finally, and unless there's more questions, I don't want to take more time from the court than is necessary.
I'll ask you, do you have a position about the exceptions clause? Do you think that it just is an exception to the jury fee, or do you think there's something else to that?
I don't think so, but again, I want to look at that as well. As Mr. Hobbs said earlier, we can submit something exceptionally short to the court on that.
Only if you think it's necessary. If you conclude that it just is the jury fee, no need.
Yes, Your Honor. You know, in closing, something that's really important here, and I know it's not lost on this court, as members of this court have recognized before, as lawyers and judges, we need to be very careful about our right to trial by jury. And the idea that we do not respect that judges and juries can come to different conclusions about things. For any of us who have tried cases and spent time in courtrooms, every once in a while the jury comes back with something that we just couldn't believe. 90% of the time the juries come back with exactly what we think. But there are times where the trial judge, notwithstanding his or her doing the very best that he or she can to consider the evidence and be fair, gets surprised. Because as a judge, you get information about the case that would not necessarily go to the jury. It would be excluded by the rules of evidence. And particularly in a case like this court has read the briefing. Half of the briefing in this case is not about the legal issues presented. It's about the personalities of the people involved and accusations and hurt feelings and all kinds of things like that.
Wouldn't that be a reason for it not to go to the jury?
No, that is the reason that it should go to the jury, because the
For emotions
judge
take over rather than the law?
disagree because of the substantial involvement that the trial judge has to have in a case like this with a trust modification, because there is more involvement. In this case, it's the reason why the trial judge here should have permitted this to go to a jury, particularly in a case like this. And that's the reason why we ask that this court uphold the 8th District Court of Appeals' well-reasoned opinion.
If you were to submit questions, maybe not necessarily in this case, but in general, about the purposes of a trust, I mean, would you just let all the counsel give a list, of anything there's some evidence, and then does the jury get to then do something like, comparative faults, and, 30% of the purpose is this, or, do they get to order them, the main purpose is this, and then the jury gets to go through and rank it 1 through 10, or how would that?
Again, I call the court's attention back to the way that you submit a breach of contract case to a jury. If the court finds on summary judgment that there's no ambiguity, then you just go in on breach. If the parties dispute ambiguity, then the parties need to argue, what is the ambiguity in the document? Which paragraph, which phrase is ambiguous? And then the trial judge, in his or her discretion, makes the decision on what exactly are we going to submit to the jury to decide what's ambiguous. It's very factually intensive, and I think it depends on the trust documents. In this case, it didn't come up because we weren't permitted to give it to a jury, but I think you would do it the same way you would do it in any case where there's a dispute between parties that have legal obligations under a document to submit those to the jury. And I really don't think this court needs to go further than picking up the business insurance and consumer PJC and seeing the way that you would submit a breach of contract case where folks are arguing that there is or is not an ambiguity, there is or is not a breach, whether or not those things occurred. Trial judges do that regularly.
In this specific case, is it right that your client didn't testify or present witnesses in connection with the modification proceeding? And so if that's the case, what is the disputed issue of fact that you contend should have been submitted to the jury?
Well, the contested issue is these first two provisions, among others, of 112.054, which is, have the purposes of the trust been fulfilled or become illegal or impossible, and because of changed circumstances not known, that the further purpose of the trust cannot continue. Those could have been submitted. And to your point, Your Honor, to the extent that trial counsel needs to make the decision at the time on who should testify and what evidence should come in, that decision is made based on, is the case being tried to the court, is the case being tried to the jury? If there had been if the jury had considered other issues in the case, that would have been a trial counsel issue to decide what evidence could or should have been put on.
And I understand what you would submit, but what is the factual dispute?
Whether or not the purposes of the trust had become illegal or impossible to fulfill. I mean, had that...
And what is the evidence that they have, I think is what Justice Bland is asking. What is the evidence that shows that in this record?
I can go back through the record and pick that evidence out for the court. Also, just because we don't put on affirmative evidence does not mean that evidence is not being elicited on cross-examination or through documents. So the fact that there's not affirmative evidence, the fact that a client does not put affirmative evidence on does not mean that there's no evidence of the case. It means that the evidence was not elicited because decisions were made at trial here with a successful outcome. As you've heard Mr. Millimet argue earlier, certain strategic decisions were made in this case based on the peculiarities of the case. And again, the court can look at the briefing for some of the things that went on. But again, we can provide a short summary of the evidence that would support these, and perhaps even consider for the court. Again, I don't want to burden the court with a lot of paper, but provide the quote-unquote charge that could be provided and the evidence that would have supported if the jury were to have returned a verdict on it. I think those are fair questions by the court. I don't know that they were fully developed in the briefing, but I think that's a fair point based on the court taking a very practical look at this situation.
I don't know that I can certainly look this up, but if you know off the top of your head, does this particular trust have a statement of its purposes?
I don't know that, but I can get that.
Does the trust code require that?
I don't think that that's an issue that the parties fought about at trial, that
No,
there
I'm
was
just
some kind of
wondering.
problem
I mean,
with the trust.
It would be if every trust has to have a statement of its purposes, then it's easy to put that in the jury charge if this
Correct.
goes to the jury.
Correct. And again, just going back to the breach of contract analysis, just because I think it's yes. Yes.
Any other questions? Thank you,
Good.
Mr. Stanton. Ms. Eckery, you have 5 minutes.
I'd like to clarify one thing. We heard that these cases are tried all the time. Issues like this are tried to the jury all the time. In Texas history, there has been one case, and it was before the enactment of the trust code, where a deviation claim was tried to a jury, and that was the Coffey versus Rice University case. And that case involved the trust that created Rice University said that it could only educate white students. That trust was written in the 1800s. In the 1960s, the trustees of Rice decided they needed to petition the court for permission to deviate from those terms. The opinion doesn't say why the case was tried to the jury. A small group, most Rice alumni supported the change. A small group of alumni intervened and opposed the deviation, and they demanded a jury. And it was tried to a jury, and that is the only time in Texas history that an issue like this was ever tried to the jury.
Or as we know from reported cases, which
Correct.
wouldn't necessarily include what's happened in trial courts
Sure.
generally.
Sure.
If you're right that the jury's not required, is it harmful error to try it before a jury?
I think that the parties can always agree to a jury. In fact, that's what happened in the Rice case. Rice has all the documents from that trial online, and there's a letter from Rice's president about 6 weeks before trial saying the opposing interveners have asked for a jury trial, and after considerable discussion, our legal counsel has decided to acquiesce in the request. They are afraid that, even if it were successfully opposed, that the refusal of a jury trial would then be a subject which could be appealed. So we know that the one time a case like this in a reported decision was ever tried to a jury, it was because the parties agreed to it. The common law, as shown in the Kennedy case and the amalgamated case, was that the court was the fact finder in deviation proceedings. Amalgamated.
You say common law, but wouldn't that be equity?
It was equity, but it was a Texas court, and if there was a constitutional right to a jury, it would have applied there as well.
Right, I understand, but there's
Okay.
common law and then there's equity in this.
Okay, sorry. But the amalgamated transit case had the same questions involved here, and it says, a court of equity will order a deviation from the terms of the trust if it appears to the court that compliance with terms of the trust is impossible, illegal, or impractical, or that owing to changed circumstances, it needs to be modified. So there's no basis in Texas law for a jury right here. It's not a cause. Justice Busby, I think you asked what are the factors. I had gotten through some of them, but another consideration is how the proceeding was handled historically. And here, that clearly supports the argument that there's not a cause. There's no
Well,
plaintiff.
Rice's counsel seems to have had enough doubt about it that they didn't want to chance it on appeal.
Well, they were trying to get this done as quickly as possible, and they were hoping to just not have an appeal at all. So, of course, I mean, if the other side demanded it and it was refused, anytime you make a request and it's refused, that gives you a point for appeal. So I think that was just Rice made the strategic decision that they wanted to agree to it.
Zachary, it sounds like you're about to hearken back to the factors that you think are relevant. As you do that, I want to ask you, have you sort of ranked them in order of importance, or as we think about formulating a test, Your brief says you check all the boxes, but are some more important than others?
I think probably the most important one is it like an ordinary cause of action? Are you getting a judgment against the adverse party for vindicating your right against somebody else?
So a key tam action is not a cause? For example, I'm trying to think of statutory claims that don't fit neatly into this historical box where you might not get a judgment against an adverse party that benefits you personally.
So that's a good question. I don't know the answer to that. I would say that the legislature or Congress can provide a jury right at any time. They could have done it in the trust code. They didn't.
But if they're silent, we have to make the call.
If they're silent, it would either have to be because such cases were tried to the juries in 1876 under the Bill of Rights, jury right, or that it's a cause. So Justice Huddle, to get back to your point, whether there's a personal right of the party involved, whether the court is acting in a special capacity with control over something or someone, like a receivership or a child custody matter, how the proceeding was handled historically, whether it's a special proceeding created and controlled by a statute, and whether that statute vests discretion in the court alone, and finally, the need for efficient, expedited resolution.
Did you articulate those in your order? In the order?
In the brief. They're all in the brief, maybe, not as the 5 factors, but they are all in there.
Any other questions? Thank you, Ms. Eckery. The case is submitted, and the court will take another brief recess.
Thank you, Your Honor.
All rise.